1994, Mrs. Pamela Lawrence was brutally murdered inside her shop in Claremont, Western Australia. After a lengthy police investigation and trial, Mr. Andrew Mallard was found guilty of this crime. After 12 years in prison, Mr. Mallard successfully appealed this conviction after the court ruled that non-disclosed evidence had caused him to be wrongfully convicted. This evidence included police statements that had been falsified, testing on a pig's head which showed that the weapon they indicated had killed Mrs. Lawrence could not possibly have done the killing, and also testing on clothing that had been submerged in salt water to see whether blood could be washed out of it or not. This is probably one of the most well-known wrongful convictions in Australia, but it's not the only one.
Mallard was found guilty in 1995 for the murder of Mosman Park jeweller Pamela Lawrence. Appeals in the following years were repeatedly dismissed, but finally a breakthrough. His conviction quashed on a miscarriage of justice, items of evidence not disclosed to his defence team, and in 2006, Mallard walked free. Andrew Mallard suffered post-traumatic stress disorder from his time in the maximum security Casuarina prison. He was awarded more than $3 million in compensation from the state, but his advocates say he never truly recovered.
The right to the fair trial is the centrepiece of the Australian criminal justice system. Anyone who is wrongfully convicted has not received a fair trial. The improper disclosure of evidence plays a large part in this miscarriage of justice. Rachel D'Ozavilla completed research into wrongful convictions in Australia. As mentioned, 74 cases were found and assessed. This was only for a period up until 2015. As mentioned, we have seen that there have been other wrongful convictions found since this time. What D'Ozavilla found was that non-disclosure of evidence played a huge part in wrongful convictions.
Australian Story discusses the non-disclosure of evidence in the Mallard case.
I indicated to the Attorney-General of the day, Mr McGuinty, that I was about to make a big speech in Parliament. The Attorney-General then, perhaps in an effort to avoid such a controversial speech being made, came to an agreement the DPP would lay on the table the whole of their file, including their correspondence file, their litigation file. The DPP took me straight to a file and said the prosecutor's brought this file up to me and has marked this page and said, this should have been shown to the defence, this should have been shown to the court, and he's looking very ill, the prosecutor, but you should read it now. And I was just stunned. I thought, what is this page?
You said that things should have been done differently in the Mallard trial?
At trial, the prosecutor, Mr Bates, had said on over 80 occasions that Andrew Mallard had murdered Pamela Lawrence by beating her about the head with a wrench. Whilst he was speaking those words, he had on his file on bar table a report which said that they'd done a test on a pig's head which had convinced the pathologist that a wrench could not have inflicted those injuries. This was crucial evidence in the trial, which he'd had all the while, which he'd marked, so he'd read, and had kept it from the court. This was something that a lawyer should never, ever do.
And in fact, in the statement of facts to the prosecution, certain police officers state their concerns that they don't think that I was the murderer anyway. That's in the statement of facts to the prosecution.
The evidence that's usually involved relates to forensic evidence or evidence that prosecutors have access to and withhold. In the criminal justice system, the prosecutors and the defence both have the opportunity to look for evidence, but usually the prosecutor can have access to a much greater evidence than the defender has, because a lot of the time the defence does not know that there is certain evidence available. This is where things seem to fall apart. Why do it? Why do prosecutors withhold evidence? Could it be because they want to secure a positive result for their trial? could it be that they just want an outcome? No one knows for sure at the moment. The research is so limited. The Court Procedures Act 2004 provides that prosecutors have a requirement to be fair and impartial and to provide all evidence that may be relevant to the defence's case. This is where we stumble across another issue. What is relevant evidence? Who determines what's relevant? Maybe if the prosecutors think it's not relevant to their case, then that's when they decide, well, it's not relevant to the defence either. Whereas in many, many cases, this has been found to be incorrect. One only needs to look at the Kelly Lane case at the moment, where only a few phone call records were disclosed to the defence. And there are thousands and thousands and thousands of phone records that could actually end up helping Kelly Lane be found not guilty in the current case. My current research proposal is going to try and identify some of these issues that I've just raised. Because this area of research is so wide, because there is so much information that needs to be looked at, and Australia is made up of many states and jurisdictions, I am currently just focusing on a comparison of the current legislation and procedures in place in New South Wales and the ACT. My aim is to then continue this research as I go through my research unit and then further on through a PhD. I aim to do this through 7 different topics throughout the research. I will have an introduction, and for this particular project, it will look at why this research is important. Speaking to Michelle Rutter of the Bridge of Hope Innocence Initiative, she has mentioned that a lot of the cases that their initiative look at have found non-disclosure of evidence to be a significant contributing factor in wrongful convictions. Michelle advised that there is very little research done in this area. David Plater is one of the main academics in the area, but at the moment, his research is limited to the prosecutor's golden rule, and that is the disclosure of all evidence that's relevant to the defence. At this stage, he is not, and nobody has, looked at the inconsistencies in each state's legislation and each state's procedures. And this is what I will be looking at through each state on a state-by-state comparative analysis. My main topics, apart from the introduction and background to why I'm doing this project, looking at the main components of disclosure requirements in New South Wales and ACT. What are the legislative requirements for the ACT and what are they for New South Wales? I am then going to evaluate the legislation for both of these states, as well as the procedures for both of these states. I'm going to try and determine what the similarities and the differences are and what gaps are missing. I'm then going to look at providing policy recommendations to address these gaps and improve on disclosure requirements. Following this up by a conclusion to search relevant and key databases such as ProQuest, Checkpoint, Lexis Advance, also just the generic UC search tool. I will be looking at key terms such as disclosure, non-disclosure, pre-trial procedures, miscarriages of justice, withholding evidence, and a combination of these terms along with the word Australia. These databases are only limited to journals. With that in mind, I will also be doing a Google Scholar search, a Halsbury's Law of Australia search, and as previously mentioned, I'll be using the UC Library Collection search tool. After this literature review is undertaken, I will then review the Commonwealth Director of Public Prosecution's summary of disclosure regimes, which was completed in June 2016. This paper looked at the disclosure regimes in all states across Australia. It did not break down into similarities, differences, and areas that need to be improved. It is also 4 years old, so I'll be looking at updating this data. It is hoped that by conducting this comparative analysis, I can develop a useful resource for legal practitioners to utilise when going to trial. And my aim is also to help there be a legislative change to ensure that disclosure requirements are fully set out for practitioners. As far back as 1981, the limited research on disclosure requirements has identified that the disclosure requirements in Australia need to change. WB Lane, there is a general reluctance to specify what evidence a prosecutor must produce. Because of this reluctance to specify disclosure requirements, there is a lack of clarity across every jurisdiction in Australia as to what needs to be disclosed. This lack of clarity leads to miscarriages of justice, such as those we've seen in the Mallard case, the Winchester case, Easterday case, and many others. The more recent research we have available has focused on gathering data. Hinton undertook an analysis of the Director of Public Prosecution policies on disclosure across all states of Australia. This was done in 2001, some 19 years ago, and is very out of date. But it did have an important finding, and that was that all relevant material is not being disclosed. Current research is also focusing on the role of the prosecutor. As mentioned, David Plater has been the key researcher on this area, in particular the Golden Rule. Plater undertook a review of all cases where non-disclosure has caused a miscarriage of justice, and he determined that it was unrealistic for prosecutors to follow this Golden Rule and to deal with disclosure fairly and objectively under the current legislation. He has recommended that this legislation needs to change. Following this initial research, Plater further went on to look at the development of the role of the prosecutor in regards to disclosure, and identified that as these roles developed, the prosecutor has become an advocate of justice, whereas they need to be a minister of justice. If they change to a minister of justice, this will ensure that all relevant material is disclosed. Plater then followed on with another research project into this area. Carrying on from what he discovered from the Golden Rule through to the ministers of justice, he then investigated the idea of prosecutors as ministers of justice and the silver thread of the law. This research led to the finding that there are major flaws in the role of the prosecutor to promote justice. It found that if a prosecutor is required to promote justice, they can't effectively discharge their functions in an effective manner. This means, as Diozavilla found, that prosecutors' misconduct are one of the leading causes of wrongful convictions in Australia. All of the previous researchers have identified similar areas which need to be researched further to ensure that prosecutors meet their ethical duty of disclosure and that the accused is offered a fair trial. The things that we need to focus on in research in the future include reviewing the current legislation and identifying any gaps and flaws, developing a formal framework in regards to disclosure within Australia, and that this framework needs to specifically direct prosecutors as to what material they must disclose. Prosecutors need to be aware that disclosure of evidence is a right and not a privilege. They cannot keep on withholding evidence that is relevant to the defence because they think it is irrelevant. This awareness can only be developed through the correction of the legislative flaws that are out there and by increasing the knowledge of all legal practitioners. This project is another piece of the puzzle to help prosecutors understand their duty of disclosure and to help ensure wrongful convictions are eventually no longer an outcome of our criminal justice system.